Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's been like 2 or 3 weeks since we got to talk about the pistol brace rule, and I will tell you that there has been no singular topic that we have spent more time on here at Washington Gun Law than that goddamn pistol brace rule. Now, I really do want to thank the folks at ATF for really helping build an audience here at Washington Gun Law, because were it not for your pistol brace rule, I think I'd probably be down at least 100,000 subscribers. I also want to thank the Fifth Circuit for getting it right and vacating this horrific piece of rulemaking order. But as it appears, well, the pistol brace rule is not done taking a beating yet. No. Instead, now the Eighth Circuit's going to dish out a little whooping on this as well. So today, let's go through the order of the court and let's talk about another brutal loss for ATF's pistol brace rule. Okay, America, coming to you from our new studios here in Kirkland, Washington. The case that we are talking about today is Firearms Regulatory Accountability Coalition v. Garland. It's a case that we've talked about before. This was one of the many challenges that was filed on ATF's pistol brace rule. What made this challenge unique is that 25 attorneys general had joined in. So you had half of the states arguing against ATF's pistol brace rule. It was filed in the United States District Court for the District of North Dakota. Now, this is where we are procedurally, so you understand this. The plaintiffs here asked for an injunction on ATF's pistol brace rule. The trial court denied that, okay? While that was going on, as we know, there was all sorts of other litigation going on over in the Fifth Circuit, which ultimately resulted in the vacating of that rule. The plaintiffs here on this case in North Dakota, however, had appealed to the Eighth Circuit the court's denial of their injunction, and the appellate court here has reversed that order of the court which denied the injunction. So they sent it back to the trial court saying, hey, you guys got this wrong. Now, unlike some of the previous opinions, which had come to the right conclusion, what I really love about the court's opinion here is they have really started picking apart the actual specifics of the rule. And so we're going to geek out on some of that today so that you guys can get educated about how this rule is getting completely dismantled. The ATF theorized that under this new definition of rifle, approximately 99% of pistols with stabilizing braces would be classified as rifles. The final rule did not adjudicate stabilizing braces systematically, such as by stating that a particular manufacturer's specific brace always transforms a weapon into a rifle when attached to that weapon. The ATF deemed it not administratively feasible to follow commenter's suggestion to provide an exhaustive list of stabilizing braces. Instead, the ATF would make its determination on a weapon-by-weapon basis. And therein begins to start the long list of problems for the ATF and this completely ridiculous rule-making order. Now, as I had mentioned earlier, this was an appeal from the trial court which had denied an injunction. So that's what the Eighth Circuit is dealing with here. And just so you understand the rule of law and how this works, the court points out, a district court abuses its discretion in denying a preliminary injunction if it rests its conclusion on clearly erroneous factual findings or erroneous legal conclusions. So therein lies the standard by which the Eighth Circuit will be judging the trial court's action. Now, believe it or not, what the ATF actually tried to argue, and they tried to argue this with a straight face, is that, hey, listen, the pistol brace rule wasn't like a final agency action. I mean, yeah, sure, we published a rule and it had this $49.99, and we allowed for all of these comments to come in, and then we just kind of reversed course and kind of changed everything, allowing nobody else to ever comment on the system that we put in place. We then issued a final rule. We put a hard deadline on it and basically said you had to bring your firearms into compliance. We even created an amnesty registration period. But, you know, it wasn't a final rulemaking order. That's actually the argument that the ATF alluded to here. The ATF claims it is not attempting to make positive law, but simply is introducing an interpretive rule which merely clarifies or explains existing law or regulations. For an agency action to be final under the APA, the action must 1. Mark the consummation of the agency's decision-making process, which I think is pretty clear here, and then 2, B1, by which rights or obligations have been determined or from which legal consequences will flow. The ATF concedes the final rule was the consummation of its decision-making process, so we must examine the second prong. And I know what you guys are all thinking right there. It's like, how could the ATF possibly, with a straight face, argue that it did not meet both parts of that 2-part test? And even the court was quick to point out, for example, when an agency requires parties incur substantial compliance costs, forego what they assert is lawful use of their property, or risk substantial enforcement penalties. And of course, that's exactly what was going on here, and it was not lost upon the court when they ruled. Here we determine the final rule satisfies the second prong. The final rule represents a sea change in how ATF evaluates stabilizing braces. It rescinded all previous brace weapon classifications, declaring them no longer valid. That means the ATF now believes many brace weapons are short-barreled rifles, so anyone possessing one may have been violating the NFA by possessing an unregistered rifle, including those parties who relied on ATF's prior classification letters in believing they were complying with the NFA. Okay, and then much like the other rulings that we have seen on the pistol brace, is it the Second Amendment that swoops in and saves all of you from this unconstitutional rulemaking order? No, it's not. No, it's not. Matter of fact, the Second Amendment is not even mentioned in this opinion really anywhere. No, it is once again the Administrative Procedure Act, a piece of legislation that was passed in 1946. And again, we come down to this arbitrary and capricious standard. Now, I think the court does a really good job here of explaining what arbitrary and capricious means. And so the court, in reaching this very just conclusion, ruled, a court simply ensures that the agency has acted within a zone of reasonableness and, in particular, has reasonably considered the relevant issues and reasonably explained the decision. That, in a nutshell, my folks, is exactly what one of the purposes of the APA is. And it's an amazing piece of legislation when you consider who thought of it, when it was thought of, and the fact that it is still effective legislation today. Now, as we know, when administrative agencies act in an arbitrary and capricious fashion, which, by the way, the ATF acts that way on a daily basis, that could be legal grounds by which rules can be overturned. What exactly does all of that mean? I think the court here has done an excellent job of outlining that for us. The agency has relied on factors which Congress has not intended it to consider, entirely failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so implausible that it could not be ascribed to a difference in view or the product of agency expertise. Now, if you recall, the way this new rule was set up, once they finalized it, once they got rid of the $49.99, is that the ATF would first take a look at the rear surface area. If they believed that there was surface area by which the firearm could be shouldered, they would then move to their next set of criteria, thus ensuring, of course, that any stabilized pistol would fall under the purview of a short barrel rifle. The court properly pointed out that, hey, listen, this standard is kind of ridiculous in the following fashion. In promulgating the final rule, the ATF decided it was not appropriate or necessary to specify a quantifiable metric for what constitutes surface area that allows for shouldering of the weapon, nor did it plan on providing any minimum surface area which would comply with the final rule. Instead, the ATF explained it will consider whether there is any surface area on the firearm that can be used to shoulder fire the weapon, and if so, proceed to Step 2's 6-factor test. And you guys realize that if there's anything on the rear part of the firearm, there would theoretically be something, it might not be very effective, but there would be something by which you could shoulder that firearm. Now, as you may or may not know, the Bureau of Alcohol, Tobacco, Firearms, and Explosive actually regulates things beyond just firearms. We don't talk about the alcohol, the tobacco, or the explosives, but as it appears, apparently ATF has a real bone to pick with those in the rocket industry as well, especially with the propellants they're using. As a matter of fact, apparently they make all sorts of rules in that industry also that are completely arbitrary and capricious, which leads to all sorts of litigation there as well. One of those cases, Tripoli Rocketry Association versus the ATF, actually serves as a basis by which the Eighth Circuit hangs its hat here. We understand that it may be necessary for the ATF to define a range of flexibility accounting for gray areas where expert discretion is necessary to characterize a particular substance. But as a reviewing court, we require some metric for classifying materials not specifically enumerated in the statute, especially when, as here, the agency has not claimed that it is impossible to be more precise in revealing the basis upon which it has made a scientific determination. And using that exact same logic as it related to why they were trying to ban certain types of rocket fuels, the Eighth Circuit points out, a similar problem arises in this case when the ATF claims the right to make an unbounded comparative analysis while insisting it has no burden to make more particularized findings. The ATF does not deny it could provide some range of flexibility in explaining the total surface area that allows for shouldering a weapon, but it does not want to, citing the need to prevent circumvention of the law. And I want you to understand that. That is the biggest rub on the ATF right there. They don't want to be clear and concise. Why? Because they're worried that you're going to circumvent the law. Now, one would think if you were a responsible law enforcement agency, you would draw some very, very clearly delineated bright lines so that everyone knew where to scribble and where not to. But see, that's not how this particular agency, and unfortunately, that's not how a lot of federal agencies want to operate. And so where this has led the court is to this conclusion. Thus, the coalition is likely to succeed on the merits of its argument that this step is arbitrary and capricious. The ATF has articulated no standard whatsoever for determining when a stabilizing brace's rear surface area would allow the shouldering of a weapon. Now, there were several other areas in which the court successfully attacked ATF's position, including about the criteria of using companies' marketing materials to determine what the true fashion was. And one of the big problems they had is, hey, listen, somebody could buy this thing as an arm brace, use it as an arm brace, be completely unaware that whatever company manufactured it is completely marketing this thing as a quasi-stock, okay? And now you want to hold this person criminally liable for a third-party advertisement. That's arbitrary and capricious in its purest sense. This is a crushing blow to the ATF, which has been suffering a lot of crushing blows this entire year. The Eighth Circuit has properly applied the law. The case has been sent back down to the district court to issue injunctive relief. We will watch carefully to see what the trial court does and see if there's any gamesmanship being played that would require further appellate intervention. The case, once again, is Firearms Regulatory Accountability Coalition v. Garland. We're going to link up the court's order down below so that you guys can geek out on it. Maybe you got more questions about this or something else related to what's left of our Second Amendment rights. If you do, you should know how to get a hold of us by now, but if you don't, that information's down there in the description box. Maybe you got an idea for a video we should be doing here. If you do, go ahead and click on that link right there. A lot of the best ideas we ever had weren't our ideas at all. Maybe you just want to subscribe to our newsletter. Hey, the information on how to do that is down below in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.